think I know almost everyone here, but for those maybe I haven't connected with, my name is Keith Hand. I'm a professor here at the law school, and I direct the Center for East Asian Legal Studies. It's my pleasure to welcome you, all of you here in person, and we have some colleagues joining us online to our penultimate East Asia event of this academic year, Redefining Dispute Settlement Norms versus Realities in International Commercial Courts with Dr. Yueming. Before I introduce her, a couple quick announcements. We have one more East Asia event. It's next Wednesday at 12:30 in room 204. One of our affiliated scholars, David Mockman, who will also be teaching Japanese law next year, will give a talk on cyber currency regulation in Japan. And I also wanted to express my heartfelt thanks to the Center for Negotiation and Dispute Resolution for co-sponsoring the event today, and the fabulous teams in both centers, Maddie Robertson, Karen Grayson, Caitlin Fleming, Brittany Tinaliga, am I pronouncing that correct? And Bianca Blau for all the hard work to make this event possible. Now it's my honor and pleasure to introduce our speaker today, Dr. Yueming Yan, and welcome her back to our law school campus. She visited us in the fall as well. Dr. Yan is a professor of law at Chinese University of Hong Kong Faculty of Law. She studies the convergence of sustainable development with international economic law, China's labor laws and policies, commercial litigation. She's also interested in China's Belt and Road Initiative. She holds a PhD in law from McGill University. She's an incredibly productive scholar who's published across a wide range of very prestigious journals. She is here today to present some very exciting new empirical research that explores how the concept of internationality in international commercial courts is prompting a re-examination of global dispute resolution paradigms. I've been looking forward to this presentation for months, so I'm not going to take any more of her time. Will you help me and welcome Dr. Yan?
Yeah, thank you so much. Thank you everyone for coming. Thank you for the two centers and Case for hosting this event. I'm very, very excited. This is actually not my first time. I was here like last fall, right, autumn, before attending the event. But even earlier than that, I was here in 2016 when I was like master's student. I had like a dress up, like friendly with the students here at Hastings. So I'm very excited to be back here, and today, and thanks for the kind and nice introduction. And my research interest actually fall within and covers many topics in international economic law. But today, my presentation will be focusing on like the international commercial courts, and also I'm happy to share that I just like signed my publication agreement with the University of Pennsylvania Journal of International Law. And so this is like forthcoming in volume 46 in this journal. So for this presentation and this topic, I think a very important thing is to know that there is a rise of the International Commercial Court, ICC. So I want to first give you an like background on this development, that it is particularly very recent development in continental Europe, like in Asia, as well as in Middle East. So if you can see that we have many like jurisdictions and countries who have now established their own international commercial courts. For instance, we have like some like countries in continental Europe, in like Germany, like the Netherlands and France. And we once in Belgium, there is like this kind of a proposal, but then they decided to drop this the idea of establishing like Brussels International Business Court. But in addition to the jurisdictions in the continental Europe, like many jurisdictions in the Asian Middle East, they have established their own ICCs. Like particularly, we have like the Dubai, Qatar, Singapore, and China. So my presentation today is going to focus on like a comparative as well as empirical investigation of 3 like ICCs, namely in China, in the Netherlands, as well as in Singapore. So this study and this project is an empirical investigation as well as a comparative study. And the main research question is to examine what is the main purpose of the ICC? Why do we establish the international commercial courts? And what are the benefits? And to see what are the main features. So to give you a basic idea of ICC, International Commercial Court is not an international court. It's not a court like the International Court of Justice, ICJ. Instead, it's actually a domestic court. So it is a domestic court established by a particular jurisdiction. So it is like domestic division in a domestic jurisdiction. However, they have their own very distinctive features. First of all, the main purpose and the mandate of this kind of like dispute resolution mechanism is to address cross-border international commercial disputes, even though like the definition and the coverage of what does it mean by cross-border and the coverage of commercial may vary across jurisdictions. And the third feature, very distinctive feature, is that some ICC, they would hire the international judge rather than solely rely on their local judge. This is very particular in the Middle East as well as in Singapore, where Singapore, they amended their constitution so that they can hire international judge to sit on the bench of the Singapore International Commercial Court. But this is not like a very common like feature, because some courts, they do not have the international judge, they rely on the domestic judge. So I'm going to present whether there would bring any difference with these 2 different approach. And the next feature is that some jurisdictions, they made it very clear that for the International Commercial Court, the language should be English rather than their official language. And for instance, in China and the Netherlands, they make it clear that they can use English as their court proceeding language. While in Singapore, because English is the official language, so Singapore still maintain using English as their court proceeding language. And there are many other features there. So the research question for this project is that why ICC, right? Because we have many domestic courts, like we have domestic court to address not only the domestic commercial dispute, but also the cross-border international commercial dispute. So why the state would like to establish an international commercial court specifically for international commercial dispute? So that is the one question. And the second question is that what is the internationality? And this is also one of the contribution of this project, because when this ICC came out, a lot of scholars and commentators would argue and demonstrate, okay, this is not international. For instance, Singapore's ICC is international, China's ICC is not international, while the Netherlands ICC, there are some debates over there. So what does it mean by international? What is the values or the pursuits of this ICC they intend to achieve? So this is the main task of this research project. And last but not least is that after establishing the framework of the internationality, the meaning of internationality, then we are going to use the empirical result rather than based on the normative rules to decide and to make proposals on how do we need to improve the internationality. Because, in the Singapore's one has been widely recognized as international, and the China and the Netherlands are not. So what kind of practical strategies the state can take to improve their internationality, to make sure that they are indeed international? So that is another perspective or contribution of this project. So here, I'm going to, the presentation will take around 40 minutes or 45 minutes, and then we reserve 15 minutes for discussion. So my outlines also follows the questions. One is to address the objectives, and then the framework of internationality, and then to present some empirical result. So for the empirical result in my project is we have both the institutional aspect, but as well as the procedure aspect. But in the interest of time, I'm going to focus on the institutional program today. And then at the end of the talk, I will also present some broader implications and the main contribution. So the first question is why? Why do we have the ICC? Why, like the United States or Australia, they do not have established their own ICCs? And it has been argued that the states have different impulse for establishing an ICC, and this could be like threefold. First of all, is the market driven, because we have, like, because of the globalization, the number and complexity of cross-border disputes increases, and which requires more flexible procedures and experienced judge. And this constitutes one main objective and a driving force for establishing a particular court. And the second is the user-driven. So we have the domestic litigation as well as in the international commercial dispute field. Arbitration has been very well and established and developed, right? However, it has been reported that an increasing number of users are not satisfactory with arbitration system, because arbitration is not very, nowadays it's becoming more and more expensive, and there are many other considerations over there. And therefore the state, for instance, the Singapore, they would like to absorb the advantages of arbitration and then to avoid the downside of the arbitration. So they want to absorb those features in a new legal system, that is the International Commercial Court. And so this is the second type. And the third objective is the policy driven. This is more a very broad strategy driving force, because it is not only for the users, but all for the development of the entire country. For instance, they want to attract more investment, because if a jurisdiction has very comprehensive dispute resolution mechanism, including not only domestic litigation, like arbitration, mediation, they would attract a lot of investment, cross-border investment, and the business, as well as the litigation business. So that is more at state level. The ICC can also serve one of these goals to attract investment, economic development. So what about the ICC that I'm comparing in this project? In fact, we have identified some ICCs, and different ICC have their different, priorities. But as a very rough evaluation of this ICC, we can see that many ICCs have their own priority, but it's not simply one objective driven. So most ICCs, for instance, the NCC and the SICC or CICC, they have been a result of a hybrid objectives. So especially for the SICC, the Singapore one, it has made it very clear in the SICC Establishment Committee report that they want to establish as a Asia legal hub to include litigation, arbitration, mediation. And this is also similar for China's one, Chinese ICC, China International Commercial Court. However, given that CICC, the China International Commercial Court, is not actually operating so far, because they have accepted very limited cases. So it would be more appropriate to say this is more policy driven, because they want to have this kind of a litigation available for the very broad, ambitious initiative that is the BRI. So they established this kind of CICC. And for the NCC, it has been reported that the main purpose of the NCC is to attract more litigation business due to the Brexit. Because of the Brexit, that London Commercial Court is still one of the very popular destination for the parties to address their dispute. But because of the Brexit, some jurisdictions in the continental Europe believe that they can, they now have a chance to have some role to play in this big cake. So that is one of the reason why the Netherlands has established the NCC. But then with this rise and development, some commentators have their comments on the internationality. But again, what is internationality? I think it is, we currently do not have any uniform standard. We do not have a list of what aspects that we should look into to examine the internationality of an international commercial court. And secondly, most of the current comments, most of the current literatures, they're based on the normative values, they're based on the normative assessment. So they look into, okay, what's the rule? The rule is that we can use foreign judge, but how the foreign judges have been actually used in the real cases, what kind of disputes have been addressed by these international judges. So this kind of empirical cases have not been like thoroughly examined, and this is the task of my project. So before we go into the empirical one, the important thing is that we need to establish the framework of the internationality. So to establish the framework of internationality, I think a very useful and helpful way and approach is to compare with other types of the international dispute resolution. So here we list 3 types. One is the ICT, International Court of Tribunals, and the second is international arbitration, and the third is the domestic court. So if we compare them like one by one, for the ICTs, I think the ICC, International Commercial Court, is quite different from the ICT's ICJ, because ICJ or like ECIJ or the International Criminal Court, they are having a very distinctive feature, which is supranational. And their purpose is not only to provide a fair dispute resolution, but also to make sure that they are independent. And they want to make sure this is a peaceful way to address the disputes among the sovereignties, among the states. So on the one hand, we want to recognize the sovereignty of the state. On the other hand, we provide a peaceful way to address the dispute. So I think the task of the ICTs, International Court of and Tribunals, and task of the International Commercial Court is kind of like different. And then the next step is to compare the international commercial courts with the international arbitration. If we have a look at the international commercial arbitration, I think one thing that we cannot ignore is that the very purpose of international commercial arbitration is to provide service. So they want to serve, it is more like user-oriented, because they want to serve the transnational business litigates. And the values underneath this international commercial arbitration is also a different one. For instance, they want to make sure that they have an expedience, because they want to expedite and they want to offer the party autonomy. They want to offer, the flexibility to the users. So it's more like user-driven. It's not about like we do not need to consider much about the sovereignty of the state, the peaceful way of addressing those kind of like dispute among the state. But this is like the disputes among the private entities. So among the private entities, like the autonomy and the flexibility and efficiency would be the most important values for this kind of mechanism. And I think the international commercial courts share a lot of like overlaps with the international commercial arbitration, because their very purpose are and the users are kind of like similar. They're private entities. They want to address they want to deal with and solve their disputes in a kind of like very money saving and flexible and efficiency way, right? And so I believe a more suitable comparative would be the international commercial arbitration. But we do have a third type of comparison that we can make, that is to compare the international commercial court with the domestic court. And I think for like domestic litigation system, the values is still maybe a different one, because for the domestic litigation system, the values could include like to be responsive to their citizens and like to the residents, and they want to maintain the stability of the entire legal system. So after comparing with not only the ICT, international commercial arbitration, as well as domestic litigation, then I think to establish a framework, to establish whether or to evaluate whether a dispute resolution mechanism is international or not, is not simply to say, okay, there is international judge, then it is international. It is indeed very important to look at the underneath the values, which is reflected in their features. And this kind of features can be further demonstrated from various dimensions. So here I presented the chart here. So I believe whether to decide the Singapore's one is international or China's one is not international, Netherlands is not international, is not simply to look at whether we have the involvement of the foreign judge or whether we have a broader scope of the jurisdiction, but we indeed need to look into whether this kind of new mechanism have achieved their purpose. For instance, to make sure it is impartial or make sure it is really professional to address the cross-border commercial disputes. So here we have the two types. One is the institutional level, and second is the procedural level. Now I'm going to address this like one by one. So now the first is about the jurisdiction. So I think at the institutional level, the jurisdiction access is one important aspect, right? So for jurisdiction, I think the first thing that comes to our mind is that, okay, how many cases are there, right? And what types of the disputes that this kind of like mechanism and could address, and also what kind of like the identity of the litigant parties. And in the current system and in the ICC, there are two types of jurisdiction. One is the consensus jurisdiction, and the other is the non-consensus. So consensus jurisdiction, now I want to focus more on the consensus jurisdiction because I think it's quite interesting here. So for the consensus jurisdiction, it means that the parties include in their contract, make it very clear that we want to designate International Commercial Court as our dispute resolution mechanism if any disputes arise. So this is one of the, and it is also argued that consensus jurisdiction would be the primary source of the dispute. And then, however, consensus jurisdiction has been recognized in almost all ICCs, but there are different levels of limitations over there. One example is China's ICC, CICC. In the Chinese ICC, the consensus jurisdiction has more like two very major limitations. One is that it requires the dispute to have actual connection with China. And second is that the dispute must be a major dispute. The amount of dispute must exceed 3 million RMB. In other words, if there is no actual connection with China, or if the dispute is like less than 3 million RMB, the CIC still does not have jurisdiction. On the other hand, the NCC, the Netherlands ICC, and the Singapore's ICC does not have this jurisdiction. So from the normative perspective, it seems that, okay, NCC and the SICC is more international, right? Because there is no this kind of limitation. And the CICC, China's one, is more limited because there are a lot of limitations over there and restrictions over there. Now I want to show you, this is from the normative aspect. I want to show you that there is actually a gap between the normative aspect as well and the empirical outcome. So in reality, if we look at how many cases they have addressed, in the CICC, because the CICC was established in 2018, so it began to accept cases in 2019. And this is similar with the NCC that established in 2019, so it started to accept a case in 2019. While SICC was established in 2015, so you can see there are some cases in 2016, 17, and 18 for the SIC, but no cases for the NCC or CICC. If we have a look at these cases, for the first few years, there is no significant difference among the cases that they hear or adjudicate, especially for the first 3 and 4 years. So in the first 4 years, the CICC has around like 10 cases. Similarly, the NCC has 13 cases. So in the first 4 years, the SICC, it seems that SICC had like 30 or 35 cases there. But there are some additional information that I want to give you. So the approach of how they name the case is different. So for the NCC, a single case, then they have a single like name number, like case number over there. NCC similar. So this is case 1, case 2. It to represent the different 2 parties and different subject matters, right? But the SICC is kind of different. In the SICC, they would give one case between the same party with the same issue, a different number of case number. So for instance, for a case between A and B, SICC would issue like 5 judgments, and all these judgments are included in this chart. For instance, these 5 judgments would include one like the order of such as the order of the evidence, and some other procedural issues, as well as the interim measures, and then the outcome, the final judgment. So if we take all this information into consideration, this number 35 should also be reduced to an even smaller number. This is at the horizontal level. If we compare with the other types of international commercial dispute resolution mechanisms, such as the international commercial arbitration, the number is like really, really small, because for a single international commercial arbitration center, they would address more than 1,000 cases per year. So not to mention like the domestic litigation, right? So in other words, this is we really have a very limited number who are actually using this ICC. And the second thing is that if you recall what I just like demonstrated about actual connection and substantial connection, this kind of requirement has been like hardly condemned by the commentators, saying that, okay, this makes the CICC, China's ICC, really not international, really like restrictive. However, let's have a look at how many cases are based on the consensual jurisdiction. So far, the NCC has never addressed any cases based on the consensual jurisdiction. They are all non-consensual jurisdiction. And the SICC, they only addressed 3 offshore cases. In other words, and all these 3 offshore cases are based on non-consensual jurisdiction. In other words, why people like we believe that consensual jurisdiction would be the primary case like sources, and we believe that actual connection, like from a normative level, actual connection would be a huge limitation to the jurisdiction, the cases that they can hear. But the reality is different. We do not have many cases based on the consensual restrictions. And even though we have a very limited number of these offshore cases, they're all the non-consensual jurisdiction. In other words, I believe there is a gap between our understanding of the norms as well as the reality. So one conclusions that we can make from this empirical comparison is that we have a lot of difference regarding the effects of the actual connection requirements, and they are actually currently minimum among the international commercial courts. And there are a lot of, the arguments saying that, okay, China, they need to have like the legal reform. It requires like significant step to reform and to remove the actual connection requirement under the consensual jurisdiction. On the other hand, my argument in this paper, in this project, is that significant step at the legislative level is important, but I don't think this is the priority of the ICC, such as in China. And I think China should it should not be the top priority for China's ICC at this present. Instead, I believe that China's ICC should make many practical efforts, for instance, to do what Singapore's ICC is doing now. For instance, to transfer many, many cases to the CICC to make sure that there are a lot of cases running in this mechanism. So if you have a look at this chart, all the cases are transferred from other domestic Singapore court to the SICC, to the Singapore's ICC. So they are not based on the consensual jurisdiction. So so my argument is that perhaps this is more practical and this would have more instant effects and outcome. So for the ICC like China and the Netherlands, a more practical is to learn from the Singapore strategy that we can transfer more cases to the CICC or to the NCC. So this is one aspect. And the second topic that I want to address and present today is also another aspect of the institutional problem, which is very interesting. That is the compensation of judge. So the nationality, right? So again, in the CICC, there are currently 12 judges, but they are all domestic judges. All these judges are from the Supreme People's Court, the highest court in China. And the SICC, we have 45 judges, some international judge and some domestic judge. And for the international judge, they are from a variety of common law and civil law jurisdiction, but most of them are from the common law, like Australia, Canada, France, Hong Kong, Japan. Japan is like the civil law, and the United Kingdom, and as well as the United States. And I just met that your friend is called upon to the bench, right?
Another U.S. appointment to Singapore.
So that is an international judge, right? Therefore, and the NCC, they have many judges, but their judges are only domestic judges. So from the normative level, it seems that, okay, SICC is really, really international because they have international judge, right? But the question is, why do we need international judge? I think it has two aspects. One, whether the international judge could bring more independence or impartiality. And second, whether international judge can bring more expertise or perfectionism. I believe these are the values of this judge, not just like international judge, but both domestic and international. They need to serve, right? Then the question is whether the international judge would increase or give us. It indeed gives us the perception that they are more independent or impartial or they are more professional, but whether this is the reality. So that's the question in my mind, and I take this question to address, to look into the empirical result. So for a judge, assuming that we have a case here, right? So the bench composition could be different, and the applicable law could also be different. If we consider independency, as well as the expertise. For the independency, it could be a case heard by one single judge. It could be one single local judge or one single international judge. Or it could be like a 3 or 5 judge panel. And this kind of 3 or 5 judge panel could be all local judge, or we have more local than international, more international than local, or all international judge. So I think at the first glance, we would say, okay, for this one, the type E, if we have more international than local, it seems that the judgment will be more independent, right? And not to mention like all international judges. So we would say, okay, why people, here I want to present a little bit more about commercial arbitration, why commercial arbitration has developed so fast and so established, because they can appoint a neutral forum, they can appoint their arbitrators, so that the arbitrators could be independent. They do not need to go to the respondent domestic local court, right? Because they kind of do not have the confidence that the local court would deliver the fair and independent impartial judgment over there. So that, with this in mind, I'm thinking whether the International Commercial Court, the incorporation of international judge, when it has this kind of purpose, or they want to achieve that we have more international than local, so that we can give the perception to the to all the businessmen that okay, our international commercial code is really an independent one, an impartial one. Not only to, in addition to that, another thing is that the applicable law. So because for the cross-border commercial dispute, the domestic law of the respondent jurisdiction is not the popular one. So basically you can decide what is your applicable law in your contract, right? You can decide, even though you are both one from China, one from the Netherlands, you can decide, okay, I want to apply the California law, or I want to apply the UK law in your contract. So the other purpose that the international judge seems that they could bring more expertise. For instance, if I have a case where the applicable law is Singapore law or is the UK law, and then UK judge can bring its expertise to hear this case, right? Because the applicable law could be like local or non-local, or the local, a hybrid one, both local and non-local. So with all these, all these scenarios, we have 6 scenarios of the bench and 3 scenarios of the applicable law. So in total, we have so many types of scenarios that could happen in the reality. Then let's have a look at the reality. Whether the nationality of judge really matter. So I think this has been a topic that has been debated for so long, not simply in the commercial arbitration, but also in the the international level, right? Like the ICJ, we have the judge have their nationalities, and International Criminal Court, they have the judge have their nationality. So whether the nationality of the judge will really matter, will really increase the impartiality of the independence. If we can have 2 assumptions, if it is not important, we can have a look at NCC, they have their all local judge. If that is important, the SICC has practice. However, if we have a look at what is really happening now, is that we have many cases in Singapore. Let's use Singapore as an example. It is like many cases are heard by the single judge, and some are heard by the 3-judge panel. However, among these 3-judge panels, in many cases, the 3-judge panel is like comprised of like 2 local judges plus 1 international judge. Then this gives us a question: does this kind of composition or this bench will really increase the impartiality, ensure that this bench is impartial or independent? So here I want to give you an example. Is that we have a couple of judges, for instance, one from Japan, one from France. So for the Japan, for like the Japanese judge, has not heard any cases so far, while the French judge has heard like 2 cases, and in these 2 cases, they issue 6 judgments. As I mentioned before, that one case, they were different judgments, but they all counted in the number of the judgment they issued in the first trial I presented earlier. So in one case, it used the French law, and in the second case, it used the Singapore law and the California law. And I think a natural question would be whether it is really necessary and fair to hire an international judge to hear the cases using the local Singapore law or using the law that this judge is not familiar with. So whether, in other words, it relates to the expertise, right? So I think this is the question in my mind, and I do find a lot of mismatch over there. Some judge from judge from UK or in Hong Kong, they all use the common law. That would be a bit easier for them. However, like French, a judge from France using Singapore law and California law, I do have the concern over there whether the French judge is really compatible, is really have the capacity and expertise, right? So However, the current judge selection is really not transparent. So Singapore ICC does not issue how they appoint, to allocate these cases to different judge, and what are the underneath consideration, whether they indeed consider the applicable law of this case when they, assign this judge to a case, and some judges are also off the list now. So I think all these findings give me some, the thought that is, we should not just look into whether there is any incorporation of the foreign judge. We really look into how these judges are used in reality. So from this perspective, I want to draw the conclusion is that I think, again, instead of making significant amends at the legislative level, for instance, if China or the Netherlands, China, for instance, if China needs to incorporate international law, China still needs to amend a lot of laws. So instead of amending constitutions or constitution as the Singapore is doing, I think more practical moves would be recommended to the China's ICC and the Netherlands ICC, which is to provide more chances and give them more cases, and for the judges to really engage in the cases and disputes. And the second thing is that I understand that, for the perception of the fairness and the rule of law in China, there are a lot of concerns over there, right? So a thing is that China has been maintaining using a 5-judge panel. So all the cases are heard by a 5-judge panel rather than a single judge or a 3-judge panel. So I think that could be a really, useful strategy to China to increase a little bit the perception of the fairness and rule of law of their, the judgment. And the third thing is that China, a very innovative one is that they incorporated a so-called expert committee. So the expert committee, they are not judge, but there are a lot of international experts from around the world. So these experts, from Russia, Macau, United States, Canada, Germany, etc., all around the world, and those experts have the role. For instance, they can do the mediation for the disputes in the CICC, or they can provide adversary opinion. For instance, so nowadays, all the cases in the CICC are using China's law. So it seems not problematic because Chinese judges are familiar with China's law. However, what if in the future, the applicable law is not China's law, right? What if in the future, they have a case where the applicable law is California law? Then this expert committee would have a role to play. They would give advisory opinion to the CICC judge, see, okay, this is our understanding, what is the law here, what is the California law. So that is where this expert would have a significant role to play. However, there is no this kind of cases under CICC. I don't know whether the CICC is actually controlling the type of the dispute, which is my guess over here. But I do think if China would like to become more international, a realistic step is to embrace more cases and to enhance the diversity of the cases, diversity of the applicable law, and the diversity of the case types in the real world. So based on these two findings, I want to make some broader implication is that we need to recognize there are some gap between the norm and the reality. When we decide when we design the norm, we have to have thoughtful and deliberate design to have some expectations and anticipation of what things will happen with this norm, and to take those kind of anticipation into consideration and then to refine our design. And the second thing is that we need to make sure that we have the corresponding policy to support the normative aspect. And the last thing is that we should not simply look into the superficial element, like the broader jurisdiction norm or the incorporation of an international law. We really need to connect those kind of aspects with the underlying values or the goals that we would like to achieve. So that is the broader implication. So as a summary, so I think this project has three main contributions. One is for the very first time, we established the framework of internationality. And the second, we applied this framework and then identified the significant mismatch between the conceptual expectation and empirical realities. And last but not least, we also made some practical reforms, both the legislative measures as well as the policy reforms, and also to give some broader implication, because we want to make sure that we're not just looking to the ICC. We want to use ICC as an example to have a better understanding of the entire international dispute resolution mechanism. So this concludes my presentation, and thank you so much for your attention.
Yes, thank you for a fascinating presentation. That was a tour de force in about 40 minutes. I learned so much. Let me maybe I can kick off the Q&A.
Sure.
So my immediate reaction was, some of the goals you laid out were the goals for international commercial court. Why wouldn't the parties just stick with international commercial arbitration, right? And so you suggested there was some dissatisfaction bubbling with international arbitration that might be related to expenses. I'm wondering if you could expand on that. But, even if there is this dissatisfaction bubbling, it seems to me the market's not responding, at least to China's version, right, by the parties consenting to bring cases there. And I wonder, the court's still a creature of the state, and the reason parties prefer international arbitration is they don't trust a state entity or a state managed entity to deliver impartial dispute resolution. That perception may be correct or incorrect, but I assume that's a lot of what's driving it. So, even if we institute all the reforms to internationalize China's commercial court, it's still a state entity. So how can China get over the perception that a state entity can't deliver fair, impartial dispute resolution?
Thank you so much for the question. I think it has two parts. The first is like the ICC, right, compared to international commercial arbitration. Still, commercial arbitration is the most popular one, because but there are indeed some users, I would say a very small number of them, are not very satisfactory with arbitration, because arbitration is really more and more like expensive now, and there are a lot of tricks over there. For instance, how do you select an arbitrators, like all the procedures, so I feel like there are indeed a small portion that they want to say, okay, do we have any alternatives over there? And commercial arbitration could be one of the alternatives, because it really save a lot of money. And if it indeed, like the Singapore's one, if it indeed has a lot of flexibility at the same level as the arbitration, they would say, why not, right? But that is our guess, still the expectation. But as a reality, as I showed earlier, we don't have any cases so far in the CIC and in the SICC. No cases are based on parties, selection. So far, no party have selected. They're all from the Singapore's other domestic court. So that is, I think this kind of reality can kind of address your second question. So why China? Right. This is very difficult. First, I think China's CICC has many difficulties if they really want to be appealing. One thing is as you said, it's still a state entity. And I would say this would take a long time first. If really China has this kind of ambitious, they wanted to, increase their reputation, or at the international level, among the international community. So they indeed do something. For instance, they establish the Council of International Expert Committee, right? They're doing this. the one thing is they do this, but how they are going to continue to do this. So far we do those kind of experts, they're just appointed. They get the certificate, or you are like appointed as an expert sitting in the CICC. However, they are not actually really engaging in any cases now. So that's another thing. So I think I would say China's one is still a very framework there. China's ICC is not really operating. Instead, the CSICC, they have making a lot of efforts. They, they promote. They have their own LinkedIn. They have the LinkedIn. They have the Twitter. They join those kind of like open house events so that people would have a better understanding. They post a lot of like, in the LinkedIn that we have this kind of event, that kind of event. So the other thing is how you sell your products, right? So I think Singapore's government really sell the SICC very well, like they are doing the Singapore's International Arbitration Center, while CICC is not doing this. So I think that is questionable. And if they indeed really want to do this, it would take a long, long time. Yeah. But I think the most important thing is that they do not have cases so far, right? So one of the strategy I present is that if you really want to increase your reputation, to make sure this is like neutral one, you give more cases to them, and so that you can let the like the scholars and the audience to see, okay, you are hearing a lot of cases, and after examining all this judgment, it seems that you are delivering very fair judgment. But the thing is that they're not doing it so far. Yeah.
Question.
Yeah.
It's a long one. I don't know if you want to.
Sure.
Take a look.
Oh, okay.
It's in the chat.
Okay, sure. Thank you so much for the informative. Thank you so much. I was checking to see why any major international company would opt for international commercial court over international arbitration. You know that international may offer efficiency, special expertise. Even more, international commercial courts are still governed local and do not offer the benefits of party selection, neutral forum, international treaty enforcement provided by arbitration. What are your thoughts on that? Yeah, thank you so much. Can I hold this up? Yeah, thank you. Thank you so much for the question. So again, I think this like relates to your first question: why international commercial court? So I don't think they do have a lot of I don't think the current disputants have a lot of preference on the international commercial courts over international arbitration. But we need to take care of the minorities, because there are some minority who really do not like arbitration. So that could be their option. And the second question is, yes, our commercial courts do not offer the benefits of party selected neutral forum. Yeah, that's the thing I also address. If we say international commercial court is international, it really depends what things you are comparing with, right? If you compare with international commercial arbitration, I don't think it's really international, because you cannot select your own judge. Even though you have international judge, you cannot select them, right? International commercial arbitration, you can appoint your own arbitrator. It could be like anyone, with any kind of nationalities. So in terms of this perspective, it has limited level of our internationality. And for the international treaty enforcement, yeah, that's another very big issue. So for the international commercial arbitration, we have New York Convention that we have more than 160 parties. So as long as you have an arbitral awards, it can be enforced almost every single part of this world. But for arbitrate courts, that would be very problematic. So one thing they are doing now is to promote the conclusion of the Hague Convention. So we do have a convention which is for the domestic judgment, not for the arbitral awards. But we have very, very limited number of signatures to the Hague Convention.
Like 80, right?
Yeah, but Singapore is a party to that. Yeah, so you can see Singapore really has made a lot of efforts to promote its Singapore International Commercial Court. Yeah, thank you again for the question.
Okay. Question here from the audience.
Yeah, so I know currently in the US, there are a number of proposed guidelines regarding the use of AI for arbitrators and ADR generally. So my question is how, if at all, AI comes into play with what you've discussed today in the framework of internationality.
Thank you so much for the question. It's a very hot topic. And we are in the AI era, so we cannot ignore AI. So for AI, there are a lot of discussion on AI and arbitration. But from my perspective is that I don't think AI can currently change the nature of arbitration or change the nature of international commercial courts. So but I do believe that AI could provide a lot of, assisting work, like, because for the judgment and the order, they are all the template. You have a template over there. You just input the information of the parties, and then you can make the decision. So I would say AI at this current stage would be saving some time and be more like efficient for the judge or for the clerk to do their work. But I do not think that AI currently has changed the nature of the international commercial dispute resolution, both the courts and arbitration. We still need to rely on the very professional experts and professional arbitrators to make the fair decision over the disputes. Yeah, but that is my perspective. Yeah, thank you.
Lena.
I wanted to go back on the point you made about do we need international judges on the ICC on an ICC because they don't have the expertise and I don't know, I might be biased, but on the French CCI PCA, they're all French, and it doesn't it's not it's not a link to a court not working because they have a lot of case on the docket but they're all French and they all have people experts coming in. And I wanted to know why do you think it's important to have people who only deal with something they actually studied or something like that? Because I mean in arbitration we also have experts sometimes when the judges think they need an expert opinion. And this is also how it's working in the French version of the CCIP. So I wanted maybe more explanation on your point because I think it confused me because I didn't really understood why, for example, a French judge would not really have a point on common law if someone explains to him I don't know I'm not sure I understood your point earlier.
Okay, yeah, thank you so much for the question. So I think my argument is that for this international job, a lot of them are the retired judge, but they again hired again by the courts, so they have a lot of experience. They've been working in their home country for 30 or 40 years, so they are very, very familiar. They are the expert of their home jurisdiction law, right? If a French judge is from France and have been working in France for 30 years, so our expectation is that he or she has many and a lot of expertise on French law. So I would say to maximize our benefits from this hiring, it would be more natural to benefit from his expertise, right? So that expertise is the French law. So why don't we just benefit the judge's benefit, the expertise on the French law? But the reality is that the SICC, in some cases, they are not really benefiting from the expertise of those international judges. They assign cases, or the applicable law is not the law of their home jurisdiction law. So that would be, they reduce the expertise of the international judge. That is my concern there. Yeah.
Sorry, I got confused because they're on the CICC, it's an international judges only, so it's not the same maybe way of giving cases to judges. Whereas, for example, on the French side, it's everybody gets the same case, different cases because everybody has the same I don't know background, except that some people may have gone I don't know to the US for an LLM or stuff like that. Whereas like on the CICC, you're very based on nationality, which got me confused because I was like, what? Because it's not something I know, and I was very, thanks for your point.
Okay, yeah, thank you.
So we'll take one more question, but I know some people might have classes at 1:40 and, you know, we're kind of at the end of our scheduled time, so don't be shy if you need to move on to your next activity, but you might
Yeah,
take
sure,
one
sure.
more. I think we
go
have
ahead.
the room for a little longer.
Thank you for the presentation. Just a quick question regarding the experts. So you're saying that for SICC, they have international judges, and CSCC, they do have like 34 experts. But how are they retired judges for the experts, or are they like current practitioner in different country? Like, do you know like a general scope?
Yeah, thank you so much for the question. You mean the expert committee in
Yes.
CICC, right? So they are very, you know, reputational practitioners. They're some of them are the arbitrators. Some are the hired judge. So there is like a combination of all types of the people in this field. So we have the higher and this is not the full time. So even though you have a full time here, you can still be appointed as an expert in the CICC. So some is the retired one, but some are very still active. They have their own like job in their own country. Yeah, but they do like sometimes they will be called upon to provide some experts' opinions, even though in reality they seldom do that. Yeah.
Thank you.
Yeah, thank you.
Thank you. Thank you very much
thank
for a
you
really
very much.
engaging
Oh,
presentation,
yeah.
Dr. Yan.
Thank you so much all.
Yes, too. Thank you all for participating today.